my attention. Off with you. Interest you on a pint? Watch your back. Talk to me. Be good.
Hi, is Rebecca here?
Yep, we're here.
Oh, okay, awesome. Hey, Rebecca.
Hi, how you
Uh,
doing?
Doing well. How about you?
Pretty well, thank you.
All right. I think everybody is just getting back from the little break that we had. So, um, do you have the slides, or did you need me to present them, or are you gonna do it?
Uh, yeah, I mean, I can share my screen if that makes
Oh, okay. Yeah. So, hold on. Let me just see. Is Shannon here, or is Alia here? One of them. Let me double check. One second.
Hi, Dave. Yeah, it's so fun to see some former interns and some people we know. It's great. Sean, you just tell us when we're ready.
Oh yeah, you could go.
Oh,
Yeah,
okay.
you could go introduce yourselves to everybody and then get started.
Okay, wonderful. Okay. Hi, we're sharing a laptop, so we're very close together. Um, Let me share my screen just so you can see the presentation from the get-go. Hmm. Um,
Well, yeah, that seems weird. Let's
yeah.
try it.
Okay, sorry, my Zoom is not allowing me to share my screen. Give me one sec. Oh, no, what? Sean, we might need you to share our slides. I'm sorry. Do you have them?
Yes, give me 2 seconds to get started with this.
Yeah, take your time. Um, but it's 4 o'clock on the East Coast on a Friday, so we will dive in. So as you know, try to do this in the time period that we have allotted. Sean will call up our slides and you will see the first slide is the agenda. And so I'll just walk through the agenda even before the slides come up. We're going to start just by briefly telling you all a little bit about who we are. We're going to go on and talk about the timeline of appeals. So you have a sense of how long appeals take. Um, After that, we're going to talk a little bit about how to set yourself up for a good appeal, how to practice before the immigration court. Then we're going to talk about appeals before the board, appeals before the Court of Appeals. And, just as a preview, we're really going to focus on the Second Circuit because that's where our practice takes place. And then we're going to hopefully have some time for questions. It's a lot to talk about in an hour, but we'll do our very best. So just to start about who we are, do you want to start?
Sure. My name is Dave Wilkins. Hi, everybody. I'm the Director of Immigration and LGBTQ HIV Advocacy at Staten Island Legal Services. I was a 2014 IJC fellow, so back when the program started. Rebecca was one of my supervisors at Central American Legal Assistance, so it's wonderful to be back. And yeah, then I worked for a little while as an asylum officer, and now I'm working in Staten Island. And we do kind of a broad range of immigration work, but predominantly removal defense with a focus on asylum and special immigrant juvenile status.
Awesome. Yeah, Dave was the first IJC fellow I ever worked with. It was wonderful. My name is Rebecca Press. I am, as of a week ago, what's called senior counsel at CALA, Central American Legal Assistance. Before that, I was the legal director of an organization called Unlocal. And I guess just briefly, I've been practicing immigration law for 14 years, and the bulk of my experience is with people in removal proceedings who are seeking humanitarian forms of relief. You can imagine that over the course of 14 years, I have lost a fair share of cases, which means I've done a fair share of appeals. So very excited to talk with you about appeals today. I think, Sean, that this might be the older version of our presentation. If you happen to have the newer version in your email, wonderful. Otherwise, we'll just talk about the other slides that we have without seeing them visually, which is not a problem.
Okay, 1 second. Let me just
I
go
can help
find that.
figure that out, Sean.
Yeah,
Okay.
it's the 9/20/23 version.
Sorry, there's a lot going on.
I know. And I think you all have been in training for a very long time. So I'm sure there's a lot to juggle. I'm gonna start even without the slides, and I'm sorry that my computer is acting funny, otherwise I would share the slides. So we're gonna start just with the timeline because as with everything in the immigration world, we're talking about a considerable amount of time, and just sort of to have an overall view of how the appeals work. As I'm sure you're already aware, you're going to be, at least in the non-detained context, you're going to be in immigration court for anywhere from 2 to 4 years. If you lose at the immigration court and file an appeal with the board, in the slides, I say 1 to 3 years, but it's really more like 2.5 to 4.5 years. The process before the board takes an excruciating long time. And then if you lose at the board and you want to file a petition for review, you're talking about another 2 years minimum. So you have a client who you start working with in 2023, and if you go all the way up to the circuit court, at a minimum, you're talking about 2030, which is pretty crazy. And really, it could be longer than that. But each stage of the process takes a very, very long time. And, just to have some sense of like how the case is going to go and when you're going to be working on it and, just the flow, we wanted you to know the timeline.
So next, we wanted to talk a little bit about, setting yourself up to have a strong appellate record even before we're talking about an appeal. Oh, great. Yes. Next slide, please. Perfect. Great. Here we go. Okay. So we want to think a little bit about preserving your issues before you even have to file an appeal. And I'm sure you've gotten training about affidavit writing and some training about, immigration court practice. So this is maybe a little bit of a refresher. But you do want to think about issue preservation, even, at the beginning of the case and moving forward before you even get to the hearing. So before the hearing, sorry, it should be one slide previous to this, please.
Oh.
Perfect. Thank you so much. So first off, of course, you want to know who your adjudicator is. Immigration court grant rates vary wildly between different adjudicators. And so knowing who you're appearing before, particularly if they have a reputation for denying, and if you can get a sense of what kinds of things they deny on, it can be very helpful to have that context before you're moving in to really prepare yourself and cross all your T's and dot all of your I's. You want to get all of the relevant documents that ICE will have access to. And so at the beginning of a case, even, it's good practice to FOIA all of the DHS documents, be they USCIS and CBP documents, and also FOIA the EOR documents, and or making a request to review the court record. One of the things that you're going to want to think about all the way throughout, and I wanted to also say that most of what we're going to be talking about today is fear-based relief appeals. This can apply to other kinds of appeals as well, but we're thinking a little bit about, asylum withholding, CAT will be kind of the predominant forms of relief we'll be discussing. So when you're thinking about credibility, you want to make sure that you're creating a record even before the hearing where you're minimizing inconsistencies, either within the narrative that the client's giving you, or inconsistencies between the client's narrative and what other documents might be in the file. And so you want to make sure that you're reviewing all of the evidence that you're submitting, thinking about whether or not there's any inconsistencies, and you want to review any other prior sworn statements by the client. So that, would it be like a CFI, screening interview, RFI, if the case had been referred from immigration, from the asylum office, looking at the asylum officer notes, which you might have to FOIA as well. And then, even when you're thinking about drafting the affidavit, because you want to minimize any opportunities for the client to have credibility issues at the hearing, you want to make sure that you're including an appropriate level of detail. What I always like to say is that you should be detailed, but not too specific in the declaration. And so you can write a really vivid story in the client's voice without giving like specific dates, specific numbers of people, specific times, things like that. And you can still give a good level of detail, but leave open a little bit of wiggle room for the client for certain kinds of details that are very difficult to remember the day of a hearing. You also want to prepare all of the corroborating evidence. If there's some corroborating evidence that should be reasonably available, but is not for whatever reason, then you want to think about if you have a good explanation for, why you can't get a letter from a certain person, why you can't get, let's say, a medical document from home country. Any letters that you're getting of testimony from other witnesses, you want to make sure that they're basically including all of the incidents of which they would have knowledge. I've had a couple of hearings where judges have been very finicky when they say, okay, well, we got a letter from your mom, but you said that your mom was present for X, Y, and Z, but we only have her letter mentioning incidents Y and Z. Why doesn't she also mention X? And so, really being careful, thinking about the letters or other affidavits that you're preparing in support. And a good case just to have in mind for these things and, corroboration specifically is matter of LAC talks a lot about, when is something reasonably available and how can you identify corroborating evidence. You also want to include all of your arguments that you're going to be making in your pre-hearing briefs. And also be sure to check all of the boxes in the I-589, particularly if, maybe you hadn't filed the 589, it's part of reviewing the entire file once you receive it and you're ready, readying a case for trial. You want to make sure that all of the potential forms of relief, even if they're secondary or even tertiary arguments, you still want to make sure that, you've ticked the boxes, crossed your T's, dotted your I's. If you're going to be relying on unpublished BIA or unpublished circuit court decisions, it can be a good idea to also submit those before the hearing so that, if it's not a published decision, the judge might not have access to it. So if you think there's a really helpful argument from an unpublished decision, I think it's a good idea to submit it in advance. And then when you're prepping your direct questions for the client, previous slide, please. When you're reviewing the direct questions, be thinking about all of the eligibility requirements that you're trying to establish. So when you're elucidating the story with the client, you do want to make sure that you're keeping key things like nexus and all the other eligibility requirements in mind so that you don't forget anything. And then, if there's any necessary motions that you need to make, if you have a witness who's only available telephonically, if you have evidence that wasn't available and that becomes available late and you have to do a motion for late filing, just make sure you file everything as far in advance as you can of the court date so that you at least have all of those motions made so that if the judge, for whatever reason, wants to deny something, then you've at least made the motion, you've preserved that issue for the future. Next slide, please. And so we wanted to talk ever so briefly about the merits hearing. Perhaps you've already had some training about doing merits hearings, but you're thinking again about preserving issues for appeal. I think a very common thing that DHS likes to do, particularly in fear-based claims, is they'll say, well, why don't we take some limited testimony on direct? Let's just get straight to the heart of the claim. But sometimes they do this as a tool to actually, so our clients are not giving sort of the most vivid and powerful testimony that they could be. So unless DHS is actually stipulating and saying, okay, we think that there was past persecution, we'll stipulate to past persecution on the record, we just want to focus on internal relocation, don't waive the opportunity to make any arguments or to present any evidence unless DHS actively stipulates to it. If your client is using an interpreter during the merits hearing, and ideally, if you can speak the language or you have somebody that you work with that can speak the language, it's important to be able to monitor the quality of the interpretation. Often there are interpretation errors that can be quite material. And so being able to bring those out is important because the transcript that you're given from the BIA when you're making an appeal does not have, it only comes in English. And so whatever is being said in Spanish or whatever other language isn't going to make it into the transcript. And so you want to make sure that everything comes out in English as clearly as possible. If the TAs want to enter any evidence, you can always make objections. Most things are fairly admissible in immigration court. The federal rules of evidence are only recommended, but you can at least, make objections as to the weight that this evidence should be given. For instance, DHS loves to put in, statements that were purportedly given under oath to DHS officers at the border. We know that these are very unreliable documents. So making those arguments when DHS introduces that evidence, saying that it should be given limited to no weight is an important thing to do. Sometimes the TA questions might misstate the record. They might be badgering the witness. So thinking about during cross-examination, preserving some of those kinds of arguments as well. And when you're listening to the client testimony, try to remember to have an objective listener in mind. I think a thing that can be hard to keep it in mind is, when you've prepped somebody so many times, when you've thought about the case so many times, it can sometimes be hard to listen with fresh ears. And so it's very helpful to prep the testimony, then even have somebody else maybe in the room with you who's listening kind of with a fresher set of ears that can hear how the testimony is coming out on that day. Is the client saying all of the details that you need the client to say in order to make the claim? It's important to be strategic on redirect. Sometimes people want to go tit for tat with every single thing that the TA brought up in cross. Sometimes it's not helpful, or frankly, sometimes it ends up digging a deeper hole if a client might flub something in testimony, thinking about, is the redirect actually going to cure this issue, or is it just going to further muddy the waters? So thinking about your redirect. And then, if things come up that you hadn't anticipated in pre-hearing briefing, it might be worth thinking about offering to do a written closing, if the judge especially has to reserve decision for a later date. So now we're assuming that you're receiving the decision. If the judge is issuing an oral decision, make sure that there's somebody there who is taking excellent notes. Whoever, the fastest typer in your office is, because when we, file the notice of appeal, and if it's an oral decision, we won't have the benefit of having the judge's decision in front of us. The only thing you'll be able to work off of is your notes. And this might seem very basic, but remember to, if the decision does not go your way, to reserve appeal at the immigration merits hearing. And another thing to think about, if you're picking up a case just from appeal, if you didn't do the underlying merits hearing for whatever reason, you can also try to review the audio files of the hearing and the decision if for whatever reason you weren't present during an oral decision. Next slide, please. Okay, so the IJ denied our client's applications. Now what do we do? So the first step is to file the form EOR-26. There is a filing fee, it's $110. And importantly, it must be received by the board within 30 days of the decision denying. And so I think this is the sort of thing that sometimes people labor over a lot. And honestly, the most important thing is just getting it in on time, because there's very little recourse if it's turned in late. If you have the written decision, you do have to submit that with the E26, but you might not have it if it was an oral decision. And then you'll be filing an EOR-27 notice of appearance, not an E28. You have to enter your appearance at the BIA, unless, of course, it's pro se. Just some quick tips on the EOR-26, which is the notice of appeal. You're summarizing the issues that you're appealing. You do not have to identify every single issue or argument that you're going to be bringing. It really is a short and to the point statement of what the judge got wrong. And we'll have an example of that on the next slide in one moment. After you file the E26 and the E27, you'll get a receipt notice from the board showing that they've received the appeal notice. And then you will receive a briefing schedule and the transcript years in the future. I mean, it might be 18 months to 2 years later after filing the E26. And so there's a lot of time where you're just sort of sitting and waiting for the BIA to act. But fortunately, the client's deportation order would be stayed during that time. Yeah, So next slide, please.
I would just add about the way I think about an appeal before the board is that the decision that the judge made is not final. So the application for relief, whatever it may be, remains pending while it's before the board. So they have no order of removal. They, it's just a pending case, which means they continue to be EAD eligible, and very little changes in their day-to-day life during the pendency of the board appeal. We included this example of a real case where this is exactly what I wrote in my EOIR 26. This is all I wrote. I did not include anything else. We wanted to include this example because sometimes people can really belabor the EOIR 26 and really sort of work themselves into knots. Like, oh my God, I have to present every single argument, or it has to be 7 pages long. No, don't do that. Write a very brief summary. In this case in particular, the judge denied on credibility alone, so there was really only one issue, right? But even if the judge denies on a variety of issues, you really summarize it. The judge erred in her analysis of one central reason. The judge erred in analysis of particular social group, of aggravated felony, whatever the case may be, and you don't go on and on. Part of the reason you don't do that is because between today, when I file, and 2 years, when I get my briefing schedule, we're going to have a whole host of new cases, right? That I'm going to want to cite to, that I'm going to want to analyze in my brief. And as Dave said, the name of the game is to get this form to the board by 30 days, because if you don't, you're in a really, really bad situation with your client, and probably like an ineffective assistance of counsel situation. We can go to the next slide, please. Okay, so you file your EOIR 26. 2 years later, you get what's called the briefing schedule. Usually what happens is you get only 3 weeks to file your brief. So you've waited 2 years to get the briefing schedule, and with the briefing schedule comes the transcript of what happened at the hearing, actually at all the hearings, the masters, everything leading up to the decision. And then they only give you 3 weeks to file your brief, which is ridiculous. So you always ask for a briefing extension, and almost always you get it. It's not a long extension. They will only give you another 3 weeks, but there's a big difference between 6 weeks and 3 weeks when you have a busy practice. So you always want to ask for it. Once you do that, that's the very first thing you do. You have to read the transcript multiple times, because there is no way that you remember what happened at that individual hearing 2 years ago, or the way you remember it is actually like really, really different than what actually happened. We had a case where a client of mine, her case was denied on credibility. I then left Kala, and Heather took over the appeal. And my memory of the hearing was that my client just did like terribly in testimony. And by the time the appeal was written, the reality was that it really wasn't that bad, that the transcript read a lot better than my memory of it. That's sort of what Dave was talking about with like the objective ears. It's very hard to hear your own client who you've worked very closely with objectively, like it truly is. And ultimately that case was granted by the board, meaning it was remanded, and she was granted asylum. So you read the transcript, you refresh your memory about the entire case. What was the evidence you submitted? What were the facts? Everything, because between the time you lost the case and now you've litigated 50 more cases. So you really have to refresh your memory. Really important to read the IJ decision very, very carefully. I know that sounds so obvious, but you really have to dig into it. And you have to spend time understanding if there were factual errors made and if there are legal errors made, because the two are reviewed under different standards of review, which we're going to talk about in a second. But you really need to dig in again to the facts. And then once you've done all of that, that's when you start writing. We can go to the next slide, please. Do you want me to start this one?
Sure.
Yeah. So just like some tips on brief writing. And I think it's like particularly important when you're just starting out practice, and like law school is like, just down the block from you. It's really not that far away. just remember that you're an advocate, right? You're not writing a legal memo here. You're not arguing both sides. You are advocating for your client. You have a point of view, and that's what you're doing in your brief. I have seen new attorneys sort of argue both sides in briefs, and that's not the purpose of a brief. The purpose of a brief is to take a position. So I know you know that, but just wanted to say it out loud in case it's helpful to someone. Writing well is not as easy as it sounds. Like you wanna be concise and compelling. I really recommend that you have people read your writing and then read it again and then read it again and take feedback as it is intended, which is to help you be a better writer. It's really important important and good to be a good writer in the legal field. Yeah, go ahead.
And I think when people think about structure, and I remember kind of falling into this trap early on as well, there's an instinct to just like follow exactly whatever the judge said and then try to rebut each of their arguments in turn. One of the problems with this is sometimes the judge's decision makes very little sense. I mean, not all of these judges are the most careful legal thinkers, and sometimes the judge's decision is such a mess, it's hard to even figure out what they're denying on. Like, they're putting multiple arguments together, they're conflating things, it's hard to suss out what they're saying. But then also, thinking about the overall structure of the brief, when you're just kind of trying to like go, and then the judge made this error, and then the judge made this error, and then the judge made this error, at some point you do need to affirmatively make the argument for why the client merits relief.
Yeah.
And so, the thing to have in the back of your mind is, if ultimately all of the IJ's errors are reversed, why is the client still eligible? And thinking about that sort of scope or that sort of sweep of narrative will help make it a more persuasive piece of writing.
Yeah, for sure. Just some basic tips. First of all, the board has a 25-page limit. So be aware of that. You can always do a motion to submit a longer brief, but truly, in my opinion, there's rarely a reason to submit a brief that's longer than 25 pages to the board. Just technical things, a table of contents, table of authorities is not actually required for a board brief. So save yourself some pages by not doing that. And use headings. That sounds silly, but headings really, like bold, numbered, whatever your preferred style is, it really draws the reader's eye in, right? And they can sort of see very quickly what you're going to be talking about in the next few paragraphs. So you make good use of that. Preliminary statements, I have become a very big fan of preliminary statements and use them a lot, particularly, well, I guess I've used them at the board, but also at the Second Circuit. I think it's a way of quickly captivating your audience, presenting the case before you dive into the legal issues. We provided a few examples of preliminary statements in our additional materials, so take a look at it, but it's a way to focus in on, like, what is this case really about? Right up front, and like, what was the wrong done and how is your client like deeply prejudiced by it? So I think it's a good writing technique and a way of presenting your compelling case right away. So I would recommend at least considering it when you're writing a brief. We can go on to the next slide, please.
And so one of the first kind of things that you're going to be thinking about when you're reviewing the decision, when you're reviewing your transcript, is identifying the type of error that the judge made. And there's kind of two main types of errors. Did the judge err on the facts, or did the judge err on interpreting the law and applying the law to the facts? The reason this is important is because the standard of review that the board is going to be using to review the judge's decision differs depending on whether it's a factual or legal error. And so, as in many other kinds of appeals and other fora, factual determinations are reviewed for clear error. Legal questions and questions of discretion are reviewed de novo.
Okay,
and
so
then mixed questions of law and fact are reviewed under a bifurcated approach.
Engaged.
And so, whatever factual determinations the judge made are reviewed for clear error, and then the facts as applied to the law are reviewed de novo. And so strategically, we want the BIA to be able to reverse as much of the judge's decisions as possible using the sort of most generous standard of review. And so when it's possible, frame whatever the issues are as legal errors, because the IJ gets a lot more deference on factual determinations. And Rebecca, I wanted to ask you, when you're reviewing a decision, when you're reviewing a transcript, how do you go about kind of sussing out what's a factual or legal error?
Oh my God, that's a hard question. But I think factual questions are really about like what happened. And frankly, everything else is either a question of law, so like a pure legal question, or the application of law to fact. In the next slide, which is, what does clear error mean? I'm going to say, and also just say it right now, that it's really a limited category of things that fall under the clear error review. We can go to the next slide if you want, or please. So it's clear error. A finding is clearly erroneous when, although there is evidence to support it, the reviewing court on the entire evidence is left with a definite and firm conviction that a mistake has been committed. So we list the three things that are reviewed for clear error credibility determinations. So an adverse credibility finding is actually, and Dave is going to talk about this more, but that's really like knife in the heart when there's an adverse credibility determination, because it's very hard to overturn. Determinations regarding date, place, and manner of entry, which can be critical when you're talking about like cancellation of removal for non-lawful permanent residents, and also when you're filing deadline for asylum applications, and then the prediction of future events, like what is actually going to happen in the future. Will the person be persecuted in the future or not? But outside of that, it's really reviewed de novo. So it's a pretty limited category of things. One example I have of a factual error, but this is really at the Second Circuit level, but essentially the board made a finding of fact that the judge hadn't made, and the Second Circuit was able to remand fairly easily because of the factual error that the agency had made. So it's just an example.
Yeah. And this is where it's really looking both at the transcript and the decision in tandem is helpful, because it can be hard, looking at how the judge characterizes the testimony or characterizes the facts often can be very muddled and totally incorrect. I mean, I feel like the judges, they're hearing this stuff for the first time. Even good judges that are trying to grant often get the facts wrong. And so I feel like when I'm reviewing a decision, I like print it out and I'm reviewing with like different colored pens, like, what's a factual issue, what's a legal issue. And it looks like a total mess by the end of it.
Yeah, we got a question in the chat. Can you argue that a credibility determination is application of law to fact? I literally was just thinking about that yesterday, because how do they, really distinguish? That is exactly what it is. That it's the application of law to fact. But no, it is very well established that judges are given the highest level of deference when it comes to credibility. So although I believe that statement is true, I don't think that we would be able to convince any reviewing court that it should be reviewed de novo.
And we'll talk a little bit more about credibility in a bit, but one of the things that's really frustrating about credibility is there's things that can kind of come across as more objective, if there's an inconsistency, if a client is testifying, with a lack of detail that seems sort of probative of a credibility issue. But then there's also things like responsiveness and like demeanor that are part of credibility determinations. And the idea is that the judge is the one who's the best placed to identify those things. Of course, trying to analyze somebody's body language as for a lot of reasons, I think it's very stupid, but it is, unfortunately, under the law, the judges have a lot of leeway on credibility. Next slide, please. And so errors of law are reviewed de novo. And so de novo review requires that the court make an independent determination of the issues. So the BIA can look at it with completely fresh eyes. They're not at all bound by what the immigration judge has decided about, interpretation of law or application of law to facts. And so the things that come up for de novo review are legal errors, and those legal errors can include due process violations and other procedural failings, application of law to facts, whether or not these facts satisfy the relevant legal standard, the meaning of a statutory or regulatory term, whether a statute applies retroactively, discretion, and then whether a crime is, for instance, an aggravated felony. So a lot of sort of crim-im determinations. A thing to point out about the due process and other procedural failings is, thinking about when you're teeing up a good appeal, and this might come up in the detained context, for instance, before the merits, even, if ICE doesn't want to bring your detained client into the courtroom, if they want them to, testify remotely from wherever they're detained, you might end up making a motion that's saying that that's a due process violation, that the person needs to be able to be physically present in the courtroom. And so you can and should think about things like due process violations, procedural failings, and even sometimes constitutional violations. A lot of immigration judges don't want to touch that with a 10-foot pole, but it is the kind of thing that we would want to preserve thinking about appeals.
Next slide, please. Thank you. So another thing to be on the lookout for is whether the IJ properly placed the burden of proof in the immigration context. The reality is that we, as representing our clients, most often have the burden of proof, but there are some issues where the government has the burden of proof, and judges aren't great about distinguishing or articulating when they're shifting the burden. We've listed a few here. The one that I'll sort of just highlight is in the context of constitutionally required bond hearings. So somebody has been detained well beyond what is reasonable, and filed a habeas, and the federal court judge orders a bond hearing. At that point, the government has the burden of demonstrating that the individual is either by clearing convincing evidence of flight risk or a danger to society. And that we see a lot of errors by failing to shift the burden to DHS, or this often happens with an individual who's had a bond hearing already, right? So like when they were first detained, they had a bond hearing. Fast forward a year and a half and they're still detained. They get another bond hearing where the burden has shifted, and the IJ says, based on exactly the same proof that I denied bond before, 18 months ago, I'm making the same finding. It's like, how do you, when the burden was ours to show by preponderance of the evidence that we're not that, and now it's clear and convincing evidence, like how does the same evidence support the same burden of proof? Just, something to definitely pay attention to. And the other thing that I think that I didn't write here, but the sort of application of the wrong burden comes up in the context of motions to reopen. I'm not sure how many of you will be doing motions to reopen, but when you do a motion to reopen based on changed country conditions for asylum purposes, your client has to demonstrate prima facie eligibility. And often we see the IJ or the board requiring that the individual demonstrate like actual eligibility for asylum rather than just prima facie. So, just things to be on the lookout for and when you're reviewing the record. Next slide, please. That's you, right?
Sure.
Okay.
And so there's a couple of common kinds of mistakes made by IJs. I mean, we've seen a little bit of everything, but I think often IJs, when they're making an adverse credibility finding, like to find omissions or inconsistencies where actually none exist. And we'll talk a little bit more about that. There's actually some very good Second Circuit case law about, how do we really look at omissions and how do we really look at inconsistencies? But judges like to sort of nitpick to death when they feel that they want to go adverse credibility. And so they'll sort of choose the absolute least beneficial way to analyze or interpret what a client was responding to when they're making an adverse credibility finding. Relatedly, and this is also actually part of credibility, judges like to talk about like the inherent plausibility of facts. And, it is something that they're technically allowed to analyze, but judges like to kind of put in their own idea of how things would work in X country or Y country. And honestly, they don't have the training or the knowledge to do that, but they love to sort of, well, I don't think a gang member would do that. And it's like, well, how the hell would you know?
Yeah.
And so that can be a very frustrating thing, but judges do often like to, get into plausibility decisions, but, thinking about that in the credibility context. They often like to also cherry pick or just fully ignore evidence. I think a lot of judges like to ignore country conditions evidence specifically, thinking about, for instance, if the government is unwilling or unable to control a persecutor, a lot of times the IJ will only look at, what happened in the instant case. Oh, well, the person didn't go to the police. So, how can they possibly demonstrate that the government's unwilling or unable? And they'll, ignore country conditions evidence that's replete with evidence that the government routinely ignores, let's say, complaints made by domestic violence survivors. So they love to cherry pick evidence that only agrees with them and to completely ignore evidence that does not agree with their negative decision.
Yeah, just two quick examples. Judge Poxer, who's a judge in New York, once denied a Honduran gang claim where on unable or unwilling, where she literally took out like the one sentence in the country condition reports that was like, Honduran authorities are trying to do something, and said like there were like 300 pages of other evidence saying that whether they were trying or not, which is questionable, they were failing completely, and she was eventually overturned at the Second Circuit exactly for cherry picking. And then just about the plausibility thing, just a couple weeks ago, a colleague at Unlocal had a case where a judge denied asylum to a trans Guatemalan woman. Basically, and one of the reasons he found her to be not credible was because he couldn't believe that one person had gone through so much persecution, that she would be persecuted. And, it's insanity. It's like literal insanity. He did grant her withholding, but they're appealing the asylum denial anyway. So this happens. This happens, and it will happen in your practice, and you'll have to deal with it on appeal. Something else that judges do all the time is that they don't engage in a mixed motive analysis in asylum claims. You don't have to show that the only reason you fear persecution is on account of a protected ground. It has to be one central reason, right? And so they often fail to engage in that mixed motive analysis. And they almost always only pay lip service to applications for withholding or CAT. Withholding it's easy for them to say, well, you didn't demonstrate well-founded fear, so you haven't demonstrated more likely than not. The CAT, the failure to pay attention or like really grapple with CAT is a really good appealable issue. They almost always, at least in New York, say something like respondent having failed to demonstrate eligibility for asylum, therefore fails to meet eligibility for CAT. And that's just totally insufficient for the multiple elements of CAT relief. So definitely appeal on that if that happens in one of your cases. We can go to the next slide, please.
So I wanted to talk just briefly about adverse credibility, just because this can be so vexed on appeals. This could be, its own training. So I'll be going through it relatively briefly. And I just wanted to provide kind of a lot of interesting Second Circuit and also, a little bit of BIA citations, so people can dig into that to the extent. Apologies for those of you who are going to be practicing in other circuits. But it's very important to know the law about border and other pre-screening interviews. A lot of circuits have looked at, how much weight should we be giving, these prior sworn statements by applicants who, might be, encountered at the Southwest border, or maybe they're giving a screening interview at an airport. There's a very good new Second Circuit case that just came out, Pomavia Zaruma versus Garland. I don't even think it's been published in the register yet. So unfortunately, I'll just have to give that a Google for now. But, an older Second Circuit case is Ramsamshire versus Ashcroft, where, the Second Circuit remonstrated the agency for not looking at kind of the context, as the client would talk about the context of the hearing or of the border interview. The interpretation was bad. They were in a custodial setting, maybe they, weren't actually being asked the questions, or they were afraid. And so, if there's, indicia of unreliability in these pre-screening interviews, then the agency needs to actually analyze that before just taking as a given that these pre-screening interviews are, God's honest truth. And so one of the things that you'll want to know, especially if a client did have any pre-screening interviews, like a CFI, a border interview, et cetera, know what like the context was. I remember one client when we had a negative credibility finding, because ostensibly she told CBP that she wasn't afraid to return to her home country. I mean, number one, she did tell them Number two, they didn't really ask her in the form that they're supposed to be asking her. But she also said, I had just come out of 4 days in the desert. I was deeply dehydrated. And she actually was like, look at this picture of me on my I-213. And we had sort of a dark laugh together because she looked like she was like, my hair was all over. She's like, look at this, like, look how I looked. I could barely speak. And of course, the IJ relied entirely on that ostensible answers to the I-213 to deny credibility. Another thing that you can consider doing is submitting reports and other evidence about, the inherent unreliability of DHS records. If the person did have a previous asylum interview, it's a little bit trickier because an asylum interview is, a much deeper and more thoughtful interview process than something like a DHS screening interview. However, there's still good Second Circuit language about how the agency must still carefully consider the reliability of asylum interviews. The asylum officer notes are not verbatim notes unless they go into sworn statement format, but that's a whole other thing that we won't get into. And so, even if they did have a longer and sort of more, let's say, reliable previous sworn statement, still think carefully about the context. The sort of overall structure of, how to analyze credibility comes from the Real ID Act, and, credibility should be analyzed in the totality of the circumstances. And so I just put the INA citation there. Generally, credibility determinations can be dependent on things like, as I mentioned, inherent plausibility, demeanor, responsiveness, candor of the applicant, all of which are, very hard to measure in any objective way. Whether or not the applicant testified in sufficient detail, any omissions, and then inconsistencies. And so there's been a lot of interesting newish Second Circuit decisions about omissions and inconsistencies. Historically, the Second Circuit actually hadn't overturned a lot of adverse credibility findings at the BIA level. And so it's great, they go through, and it's often very fact specific, but in these decisions, they go through, when is a perceived omission where a client might have mentioned something in their asylum application or didn't mention something in their asylum application, and now they're mentioning it at the hearing. Why didn't they mention that before? That's an omission. Or, if something's an inconsistency, like when is it really a meaningful omission or inconsistency? Because under the Real ID Act, the judges can use things that don't go to the heart of the claim as the basis for an adverse credibility finding, but still in the totality of the circumstances, the person has to be found not credible. And so these decisions are kind of looking in the totality of the circumstances, are these inconsistencies or omissions really material enough to find somebody not credible? There's also a good citation from Pavlova versus INS from the Second Circuit, where it is actually permissible to elicit additional detail at a hearing. A client doesn't have to have said every single thing in their written submissions. They can add more detail. They can sort of deepen a claim as they're talking about it during direct. One other thing I just wanted to mention, sort of in a pre-hearing strategy to inoculate against certain types of credibility issues, if you have a client where you're just really worried about their ability to tell a chronological or detailed narrative, it can be worth, thinking about getting a psych eval, talking about memory issues or, effects of trauma on somebody's ability to testify. Or even, if you think that there's some real competency issues, if it rises to that level, asking for an MAM hearing. Even if the judge doesn't grant you that MAM hearing to provide safeguards, then you've at least still kind of raised that issue as, potentially relevant to any further credibility analysis.
We can do the next slide. There was a question about if you are granted withholding but denied asylum and appeal, and you're in ICE custody, will you remain in detention? I don't know what you think, Dave, but I think you would have a very strong bond application. You'd have certainly changed like if bond had been denied and withholding is now granted, that's certainly a changed condition to ask for a new bond. And it would be before the same IJ who just granted you your client withholding. So I think you'd have a pretty good shot at being granted bond at that point. That said, like, ICE is horrible. We never know. And you might have to fight it, right? But it's a pretty good odds. A couple things just, as we move out of the board and into Second Circuit, is just remember, if you are working on an appeal that has to do with a client who is not detained, You're almost never going to get a DHS brief, which means you really are controlling the narrative. And you're like not arguing against anything. They essentially rest on the record. Capitalize on that positive credibility finding. If your client was found to have testified credibly, that means everything they have said is true, undisputed fact. Use that to the best of your ability. Of course, preserve issues for potential appellate review, but you don't have to go through like every eligibility requirement again. You like focusing on the reasons that the judge relied on to deny the case. You want to take the last two?
Sure. I mean, I already mentioned this.
Yeah.
If there are any due process or procedural violations, don't forget to raise those. Sometimes it might get a little bit lost in, thinking about the merits of the case, or the, eligibility requirements of the case. And also just think about, what are we asking for? Depending on the type of error, do we want the BIA are we requesting the BIA just grant asylum? Or is it something where the BIA would need to remand, for more factual development or something like that? And so, also being strategic about what are you asking for in your conclusion can be helpful.
Yeah. Next slide, please.
Okay, before the next slide, I got to give out the CLE code.
Oh.
So the CLE code is East River 10. So East River and the number 10. And then I'll switch to the next slide for you guys.
Thanks, Sean.
No problem, you go.
Okay, so we're now, 5 years later, the board has upheld the IJ decision, meaning they say there's no way for us to overturn this decision. This decision still stands. And now your client has a final order of removal. They've made a final decision. At this point, you're deciding, are we appealing to the Court of Appeals in whatever jurisdiction we're in? It's called the petition for review in the context of the Court of Appeals. You have to file your PFR within 30 days. In New York, I do not know how this works in other places, but in New York, you file through a system called ACMS. It's all electronic now, and you have to email what's called OIL, which is the Office of Immigration Litigation, and it's part of the Department of Justice, to say, like, I'm filing a petition for review. The actual filing of the petition for review is really easy. I should have included an example, but it's literally just, I'm filing a petition for review based on the denial dated whatever. It's like literally all it is. So it's not that hard to get it started. It is very expensive. It is $500, but you want to pay that fee, and I will tell you why. Because if you can't pay the fee, you have to file what's called an in pauperis forma petition. And it's very, very risky, as I say in the